Okay, like I told you before, ignorance of the law is no excuse. It's been around for a long time. It's a part of this democracy thing, in any republic, where they have a constitution, nation of laws. It's a key component in so it tells you if a government official or regulatory official provided you with incorrect written guidance and you break the law by following it, you may be granted leniency through the concept of entrapment by estoppel. Okay, so, but it can account in some cases, but in general, they will use that against you in a court of law. And Jefferson's once noted, if ignorance were a valid defense, the laws would lose their effect because it would always be pretended if it prevents individuals from using willful blindness to act with impunity. Fairness and order. Laws are designed to apply to everyone equally to maintain a functional society. An exception that citizens make themselves aware of legal parameters of their communities. So basically, laws in general, anything that would be, considered the norm. But there's a lot of laws that I seen a video where a judge was telling you or saying, anyway, he was saying the Miranda rights were common knowledge and the cop didn't have to read them and everybody should know about that. Okay, so ignorance of the law, they say, is no excuse. And this is that fundamental principle been in law for quite a long time. But they started this qualified immunity here in Pearson versus Ray in '67, a landmark U.S. Supreme Court decision that established the doctrine of qualified immunity for police officers and reaffirmed absolute immunity for judges under Section 1983. And, let's just a background. 1961, a group of 15 black and white clergymen attempted to use a segregated interstate terminal waiting room in Jackson, Mississippi, as a peaceful Jackson, Mississippi, as a peaceful protest. Local police officers, including J.L. Ray, arrested the ministers under state breach of peace statute, was later ruled unconstitutional in a separate case. The ministers were convicted, spent months in jails, and subsequently sued the police and the municipal police justice for unconstitutional false arrest. It violated the rule of law. Segregation violates the rule of law. Supreme Court ruled in favor for the officials on two distinct grounds. Judicial immunity. The court held that judges had an absolute immunity from liability for damages under Section 1983 for acts committed within a judicial jurisdiction, even if they act erroneously or maliciously, not in the public interest, in the interest of the bar, thus under the color of law. That's my legal argument. Qualified immunity for police. The court recognized a police officer should not be forced to choose between being charged with dereliction of duty or being sued for damages. Established police officers are entitled to offensive qualified immunity if they acted in good faith with probable cause when making an arrest, even if the underlying statute was later declared unconstitutional. Okay, segregation, it's pretty simple. That violates the rule of law. Okay, it violates the rule of law. That's why it's unconstitutional in the short terms. So how is it ignorance of the law gives your public servants qualified immunity? Because he thought, the sign on the wall meant something. It was a segregated sign. Use a segregated interstate bus terminal waiting room in Jackson, Mississippi as a peaceful protest. They were actually waiting for a bus to leave. They were having coffee together. Local police officers arrested the ministers under state breach of peace status, which was later ruled unconstitutional in a separate case. Freedom of religion, in a free country, freedom of speech, the rule of law. I mean, it's clearly logical. Everybody should know that. But because they didn't know that law was unconstitutional, it was racist, but because they didn't know it was law, they get qualified immunity. The ancient Roman maximum: ignorance of the law is a foundational legal principle. And okay, so law repugnant to the Constitution is void, because the U.S. Constitution is supreme law of the land. Any legislative act or statute that violates, conflicts, or overreaches constitutional limits carries no legal authority and cannot be enforced. That should be common knowledge, at least those in law enforcement, and they're supposed to be held to a higher standard. Why would they put anybody in law enforcement that's ignorant of the law? And I spoke to many of them, and it turns out they knew more about the law than they pretended that they did, and left me alone. I mentioned violating the oath, and that's deprivation of rights, and that's a federal crime, especially now with the phones. You could just pull them out. They have a code of conduct, violating that code of conduct. The oath they took. And I told him it'd be nothing but legal harassment and no probable cause, and I'll see to it that the case gets thrown out on that. And then when they throw it out on no probable cause, they're going to have to cite you for making a false arrest. But either way, why it seems ridiculous that they would put people ignorant of the law in law enforcement. And when you go to court, I always preach about learning the rules, professional conduct, the code of judicial conduct, taking copies with you to court, and demanding everybody play by the book. That's your constitutional right. And remember, you have a right to assert these rights in a court of law. If you're going to protest, do it on the proper platform when you walk into that court of law. Okay, that's the way to protest legally, and that's where you make a difference. Remember, so if they claim, they have this qualified immunity, well, That's repugnant to the law. The qualified immunity started based on ignorance of the law, and according to the law, ignorance of the law is no excuse. Remember, you took an oath to the Constitution, and the Constitution was written to serve, protect we the people. Let's not forget, violating the oath. Oh, let's go here. The oath of public service, formerly the oath of office, is a solemn pledge taken by all U.S. civil servants, military personnel, and elected officials to support and defend the U.S. Constitution, outlined in 5 U.S. Code 331. It binds public officials to serve the Constitution and the American people above any specific individual or political party. Okay, let's go there. And the individual except the president elected or appointed in office, honor, or profit in the civil service on uniform service shall take a following oath. I do solemnly swear to affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and I will bear truth to all allegiance to the same, that I will take this obligation freely without any mental reservation or purpose or evasion, and I will do faithfully discharge the duties of office of which I am about to enter, so help me God. And remember, an unlawful order is a directive from a superior that violates the U.S. Constitution, federal statutes, or military law. Service members are legally obligated to disobey manifestly illegal commands, e.g., targeting civilians or committing crimes as the following them does not shield you from personal criminal liability. For deeper dive that constitute an illegal command. Okay, crimes of war, directives, intentionally harm civilian, tortures. Okay, demands to perform personal service such as babysitting or running errands, falsifying documents, military all orders that are presumed unlawful. And it gets down to where the point is just taking orders is not a legal offense. And you know, ignorance of the law is not a legal offense for anybody. That applies to everyone. Qualified immunity was created under the color of law, not in the public interest, clearly in the interest of the bar. All public servants are required to do what's in the public interest. And it even says so in the preamble. Okay, I did that one earlier. Oh. Oh. I don't know why. Maybe because I read it so much. The legal profession's relative autonomy carries with special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not furtherance of parochial or self-interested concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also abide in securing the observed by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. So what do you think, public? What do you think? I'm telling you, they put a whole lot of stupid on that qualified immunity. But my mind goes in so many different places. So, I mean, when I read, like I said, ignorance is no excuse to, ignorance of the law is no excuse. And why did they create qualified immunity? And when did it start? And then I found out when it started, and it just doesn't make sense. Qualified immunity clearly under the color of law, in the interest of the bar. Okay, not in the public interest. Okay, and it says right here, public interest which it serves. That definitely, qualified immunity is not in the public interest. If that didn't exist, you wouldn't have public servants needing it because they keep violating your constitutional rights. Remember, these are their constitutional duties, the rule of professional conduct and the code of judicial conduct, as well as your constitutional rights. Okay, so this falls in the sphere of your constitutional rights because they took the oath to do this, and this is guaranteed by the Sixth Amendment of the U.S. Constitution, known as effective assistance of counsel, and those requirements are in both the rules of professional conduct and the code of judicial conduct, the legal responsibility of all lawyers and judges in every court of law. All right, thank you and good night. Nothing but peace and love to you. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Thank you and good night.